question of Mr. Modi and his responsibility at that stage. I want now to go to my two other lawyers to actually broaden the discussion. I'm moving, Dushyant Dave, beyond this question of whether President's rule has been commented upon and nullified or not. That's a debate that we've had between the two party spokesmen. I want to now draw your attention to the fact that this judgment actually goes beyond simply restoring status quo ante to the 15th of December. It strikes down decisions taken by the governor, such as advancing the assembly session, the directions that he gave the speaker about how to conduct that session. So would you say that this judgment is a much deeper judgment than just reversing the clock? It actually also gives sufficient sweeping instructions on the behavior of constitutional authorities. It's therefore a much deeper judgment.
Well, it is indeed a far-reaching judgment. Most of all, forget whether the Congress government is restored or not. I am not concerned about that. What it really restores is the constitutional morality, the ethos of the Constitution, the constitutional principles, and the very, question of the role of a governor vis-a-vis an elected government in a state. So this judgment, to my mind, is so supremely, good for those of us who love Constitution, that for a long time to come this judgment is going to govern the, the conduct of constitutional powers by constitutional functionaries, and really restores the faith of citizens in this beautiful theory of checks and balances, where the executive, legislature and the judiciary each have their powers, but each have the duties, and how those powers and duties have to be exercised by each. And if you overstep the exercise of those powers, if you abuse them, then there is another wing which steps in to check that. So this really is a brilliant judgment, and I think hats off to the Supreme Court that it has not only given idea about the constitutional position, but restored the status quo ante as on 15th of December 2015, which is really absolutely a necessity. Now, so I think it's a great thing that has happened for us as a democracy.
Mr. Arinasundaram, in the case of Uttarakhand, the Supreme Court restored a dismissed government. This time, I believe it's gone one step further. It's actually removed a sitting government, which has an apparent majority, and then it's wound the clock back to restore the predecessor to the predecessor government, because the immediate predecessor was President's rule and the predecessor to that was Nabam Tuki. Is that a second reason why this is a seminal judgment? It actually takes the situation back not just 6 months, but back to two earlier governments.
In fact, Karan, I don't think anyone can but say that this is a far-reaching judgment. It is very far-reaching, yes. Again, I do not think anybody can say that the Supreme Court judgment does not interpret the Constitution as it stands. But the answer to your question, I believe the problem lies within the constitutional amendment itself. When the 10th schedule was originally brought in, when the amendment was brought in, the 52nd Amendment, there was a room for a so-called split in the party where it would not attract the anti-defection. The reason, I think, was that a party is not just the name of the party, but the persons who make that party. And if a substantial number of people who make the party cannot follow the leadership at that given time of the party, then that substantial number, whether it was 30%, 1/3, whatever it was at that given time, moving away, would not attract the disqualification. Now the Supreme Court, subsequently, unfortunately, the Constitution was further amended and that was taken away. So today, if 95% of a given party move away, and then 95% of that party is not supporting, the MLAs are not supporting the leadership. Now they get disqualified and the leadership continues.
But that's not the question
now, this is a great anomaly according to me. And the Supreme Court has rightly interpreted the Constitution as to what it is. But I want to know what the practical effect is. No, I'm going to this question of setting the clock back. You're setting the clock back this way and bringing in, reinstating a government which is brought in today, whose leadership is not meeting the majority of the House. It's an anomaly. In my book, it's a practical anomaly.
Let's take that in a moment's time. You're raising the question, Mr. Sundaram, of whether Nabam Tukki can survive now that he's been restored, and maybe he can't. But let's take that separately. The point I was making was a very specific point, that this is a judgment that goes further than Uttarakhand. Uttarakhand restored a dismissed government. This judgment has actually removed a sitting government. And therefore, it is a judgment that goes further. And it's not just wound the clock back one stage, it's wound the clock back 2 stages.
And that is the anomaly.
Okay.
You see, it is a...
Carry on.
Karan, I agree with you.
Sorry.
I am saying that's exactly what has happened, and perhaps as the Constitution stands, that had to happen. But that is the anomaly which is going to arise now.
Absolutely.
Which I find very difficult.
I'll come to that anomaly in a moment's time.
At the constitutional amendment.
I'll come to that anomaly in a moment's time, because it is to do with how the future works out hereafter, and whether Nabam Tukki is simply restored as a chief minister who now lacks the numbers to survive. But let's leave that for part 2 of the show. I want now to focus on another implication, and I'll come to you, Mr. Mittal. I see your finger up. I want to focus on another critical implication of today's judgment, what it tells us about the behavior of key constitutional authorities. And first, Mr. Mittal, I'll come to the governor. In January, when Mr. Rajkova assured the Supreme Court that nothing untoward and precipitative would happen, it emerged that, in fact, he was giving a false assurance to the Supreme Court, which was misleading, because shortly after giving that assurance, he actually recommended governor's rule and never told the Supreme Court he'd done that. That was one critical lapse on his part in January. Now, the Supreme Court has deemed his decision to advance the Assembly session and his instructions to the Speaker how to conduct that session as violative of the Constitution. That's 2 further black marks against him. Can Mr. Rajkova continue in office? And if he doesn't voluntarily resign, shouldn't the government sack him?
Karanji, very sorry to say, but your facts are completely at variance with truth. At no stage has Mr. Rajkova assured the Supreme Court, and he has gone back on his assurance. Please understand that
was January, sir. It was January, it was an acknowledged fact.
Sir, I know it. I know this case much better. Sir, I know the case much better. Sir, please allow me. Karanji, but if the facts are not what you are saying, please have the humility to accept it. I know the facts of this case at the back of my hand. So don't challenge me on the facts. Now, what I am trying to tell you is, I so eloquently heard Mr. Abhishek Manu Singhvi talking all that. I don't think he has even read the judgment. Because I'll come down to the most important operative part of the judgment, which nobody seems to be even addressing themselves to it, but which I'll leave it for the last part of my debate. The issue is simple. The Supreme Court has interpreted the powers of the governor. Till now, there was an issue as to what the governor can do and what the governor cannot do. The Constitution said he can have discretions, and in case what he thinks is his discretion, that he has to act in his own discretion, is something which is his wisdom and that cannot be challenged. The Supreme Court has laid down, no, you cannot order the preponement. It has laid down principle.
I don't believe it was ever deemed by anyone that this was part of the governor's discretion. Mr. Rajkova assumed it was part of his discretion. No one else agreed with him. The Supreme Court has now told him it never was your discretion. You were wrong to do it to begin with. You were violative of the Constitution. This argument that you're presenting, that it was earlier deemed to be part of the governor's discretion, is an excuse you're devising to cover up for a terrible constitutional lapse by the governor. And that's why I ask, if he doesn't resign, should he not be sacked?
Karanji, there were 6 earlier cases where directions of this kind were given.
Wrongly so.
Let's not just make sweeping statements. Issue is, this is a constitution bench, and the constitution bench has laid down principalities. It has laid down what the law of land is, and it has, in this judgment, clarified the position of powers of the governor vis-a-vis the assembly.
Let's get someone else in on that.
The direction the governor
That's your argument. Let's see if Abhishek Singhvi agrees. Do you accept the argument that you're hearing from Mr. Mittal, that all that the Supreme Court has done is to clarify what is the area of discretion of the governor, that earlier it was unclear, and therefore perhaps Mr. Rajkova was right in giving directions and right in preponing the Assembly session, and that it wasn't, when he did it, a clear violation of the Constitution. Now, on clarification, it's been deemed to be. Abhishek Singhvi, do you agree with that interpretation? Abhishek Singhvi?
I think anybody who has either read the judgment, or knows an iota of law cannot possibly agree with what one is hearing. 3 or 4 points I wish to make. According to me, Mr. Mittal has not answered a single one of your questions. He has answered them by saying that other people are presumptuous in speaking without reading judgments. Now, if he has read the judgment, he should tell you that there was a direct frontal attack on the conduct of the governor from day one, from 9th December when he purported to prepone right onwards, 9th November when he purported to prepone onwards. Thereafter, the directions which he gave. Thereafter, all the other actions he took. He was in the dock. He was the central accuser in the dock. Now, at least after a constitution bench, the representative of the BJP should have the grace to accept that the governor has erred. We accept that Mr. Bhutta Singh erred. A governor like Mr. Bhutta Singh, like Mr. Rajkumar, is not infallible. Now, to fudge it by saying that it is nothing but a small discourse on discretion of the governor is completely avoiding the issue. Thirdly, Karan, I think it is time to applaud that the Supreme Court is time and again now giving judgments which are not mere sermons 3 to 5 years after the event. That's a very important point. Uttarakhand was the first judgment, though by the High Court, where a live, active situation was reversed. Arunachal, though slightly belated, is almost a live situation being reversed. That is very telling because it's a lesson for the future. The lesson earlier was not a deterrent because things came, this Bomai came 5 years later, this Bihar came 3 years later or 4 years later. Today, there is a live intervention by the court which is rightly reducing such misadventures of 356 or governor's directions or interference in the assembly to naught. And lastly, Karan, this is a judgment which is an advance on the normal situations of interference because it lays down clearly, because along with 356 or along with interference, governors are giving directions within the assembly fold. Now this demarcation of organs of state constitutionally, that one shall not look into the other, and that the governor must act on the advice of the chief minister, is the central focus of the legal part of this judgment.
Sure.
And this has settled the law much more than any of the 356 judgments, either this Bomai or Rameshwar, on this subject.
Dushyant Dave, we've talked
piece of advance of the law purely in legal terms.
Dushyant Dave, we've talked about how the governor emerges, and I've raised the question whether he should resign in the face of the stinging criticism he faces. But it's not just the governor alone. The governor, at the end of the day, acts at the behest of the central government. The central government consists of directions given by the cabinet presided over by the Prime Minister. This is the second time within 2 months that a declaration of President's rule, whether directly in the case of Uttarakhand or by clear and honest implication in this case, because everything from December 15th onwards has been declared unconstitutional, has been thrown into question. How does Mr. Modi emerge from this? 2 declarations of President's rule seriously questioned by the Supreme Court.
Well, Mr. Mittal may be right in saying that there is nothing about Mr. Modi's government. But let us understand one thing, that the governor is the agent of the central government under the constitutional scheme. And I will read 3 sentences of the 3 different opinions by Justices Keher, Justice Mishra and Justice Lokur, and that those statements tell you that really the responsibility lies somewhere else, not just alone on the governor. This is what the Supreme Court says: the governor must keep clear of any political horse trading and even unsavory political manipulations, irrespective of degree of their ethical repulsiveness. This is what Justice Keher says. Justice Mishra puts it beautifully and says that you must have constitutional restraint and you must follow discipline. And Justice Lokur puts it much strongly and says there is a concept of responsible government under the constitutional scheme. Now all these are really indictments on the part of the central government, because governor really acts under the advice of the Home Minister. And this, there is a presidential proclamation here which was on the advice of the Council of Ministers. What is really regrettable is that the Council of Ministers today comprises of some of the most eminent lawyers who are universally respected. So I am really shocked that those lawyers did not advise the government. Equally, the government has the battery of law officers headed by the Attorney General who never advised the government of India properly. All this really reflects extremely, unfortunately, a sorry state of affairs in our, body politic, that everybody, irrespective of their constitutional role, is acting as political agents of party in power. Be it Congress during Congress regime, be it BJP during BJP regime. So really speaking, this has really thrown a debate very wide open. It reflects unfortunate situations in the country, and I hope, and I would really, I would say, trust BJP to have a much more sober, much more responsible response to this debate, rather than what Mr. Rao said sometime back on television, or what Mr. Mittal says now.
Mr. Sundaram, let me bring you in on that key critical point. There is no doubt that Mr. Mittal is correct when he says that President's rule is not covered specifically. No comment is made about the central government, leave aside the Prime Minister. He's correct technically, I don't deny it. However, when everything that happened post-December the 15th is deemed to be unconstitutional and illegal, and the clock is restored back, that clearly has serious implications for the behavior of the Prime Minister, the Cabinet, the declaration of President's rule, and let's be honest, it also has implications for the way the President assented to it, because the President had the option of doing what President Narayanan did, which was to ask the government to reconsider. He didn't. How do, therefore, a whole spate of constitutional authorities, the Governor, the Cabinet, the Prime Minister, the President, emerge from this denouement?
Karan, whatever be the utopian concept, let's accept one thing. Ever since independence, ever since Panditji's days, Indira Gandhi's days, everywhere else, the real cards always lay in the hands of the Prime Minister. We all know very, very well that over the years, whether it was the Congress party, and we saw the number of times 356 was invoked during the Congress regime, we know that this is something where the government has always held the cards, and it always traces back to the central government. That is why I'm saying that the whole issue here is that finally, whether you like it or not, it becomes a political game. Now, when you find that there is a legislative assembly where 90%, 80% of the people don't want that chief minister, now naturally the opposition party is going to go around and say, is this a real representation by the people? Is this real democracy at play? It's all very well to say, yes, democracy means that party continues, but if the person who's there does not have the support of his own party, does not have the support of his own party members, what is to be done? This is the anomalous situation, and I feel the way we are heading today, it's all very well to talk about the Constitution law, which is very clear, and the Supreme Court judgment absolutely bang on in interpreting the Constitution. But the effect of all this is, how do you expect that when it's a political party anywhere in power, whether it's the opposition or the ruling party, who will not take advantage of a situation when the other party itself is so decimated in its ranks, is so full of infighting, is so full of infighting that they're not even able to form a government.
You're providing an extremely eloquent exoneration. You're providing what I...
natural invitation.
You're providing, Mr. Sundaram,
without utopia.
I'm interrupting you, Mr. Sundaram, because you're providing a very eloquent exoneration of the behavior of constitutional authorities like the Governor, the Cabinet and the Prime Minister, just to name those three, and you're saying that when in fact the party is
not exoneration, it's reality.
It sounds like
not
one.
Utopia.
Let me put that to Mr. Mittal, because it's the first time something said by the other three members on this panel has brought a smile to his face. Do you accept that in fact the fault lies in the way the Congress party was collapsing, and the fact that 95% of the Assembly didn't want Mr. Tukey to continue, and therefore, regardless of what the Constitution says, which the Supreme Court has upheld, the practicality on the ground made it impossible for the Constitution to apply? That is the nature of the explanation or exoneration you're getting. Are you happy with it, Mr. Mittal? Because it's the only answer that works in your favor today.
No, I don't need any answers to work in my favor. There is a ground reality which you all don't seem to be appreciating. Because of the misconduct of Mr. Rahul Gandhi, who refused to even meet the MLAs with grievances for 6 months here. I mean, Kaliko Pul was here camping for 6 months, and Mr. Rahul Gandhi did not even meet him. You have problems in the Congress and you want to blame BJP for that? That's strange. Can you imagine the disregard or the humiliating behavior which can be subjected to by for these MLAs?
And that justifies all that happened from the 15th of December onwards, which was reversed by the Supreme Court. That's what you're saying. Rahul Gandhi's refusal to meet Congress's inability to handle dissent in their ranks justifies what happened.
I'm not even bothered what happened there. It is an internal matter of the Congress. They did not come and join BJP. BJP is not even a party, part of the government. So if the problem of the Congress is there, if they are fighting, if they can't hold their flocks together, you want to blame us for what? And as I said, I take serious offense to what is being said here. Whereas the Prime Minister, see, the Prime Minister is not even named in this. There is no mention of the central government. There is no mention of anybody.
That's been acknowledged, Mr. Mittal. That was acknowledged in the question. So don't take offense at the fact that was acknowledged in the question. I'm going to go back to Abhishek Singhvi.
Explanation is this?
Before I take a break, I'm going to go back to Abhishek Singhvi to comment on the point made by Mr. Mittal that this whole situation arises out of the inability or failure or incompetence of the Congress to handle dissent, and as a result, when the Congress was collapsing, a situation that was impractical happened on the ground, and even though the Supreme Court has ruled by the Constitution, the reality on the ground was something else. That was an argument made both by Mr. Mittal and by Mr. Sundaram. A quick response before I take a break.
We have just heard two theories which will spell constitutional chaos even if accepted by implication. If there is instability in a government, if a BJP set of MLAs does not obey their master, or if a Congress set of MLAs doesn't obey their master, the answer lies in bringing a legitimate no confidence and winning it. What you call a constitutional sin of defections, what you call disaffections, and what you call using the help of a friendly central BJP government is not prescribed in the Constitution as a panacea for disgruntled MLAs. You tried it in Uttarakhand, you are trying it here. And to give a kind of a political answer to the illegalities successively of everybody who looked at it. Just half a minute, Karan. After all, who would have advised on Saturday in Uttarakhand to have President's rule? Not without the top central leadership with the Prime Minister heading it, with the Attorney Generals looking at it. Who would have advised this kind of action? Do you think Rajkova is competent to do all this? Now, you justify it by saying, oh, but what is to be done when the Chief Minister sitting has lost a majority? Just imagine the consequence of accepting that argument for constitutional chaos in this country.
Absolutely.